Welcome back to Unlocking the Law, a podcast where we tell authentic stories about the law, break down barriers that you may have to working with attorneys, and we try to explore topics of interest to businesses and communities. We try to do this in a modest way with a little bit of humor mixed in here and there. The podcast is brought to you, of course, by the law firm of Walsh and Grysko, and I'm your host, Brandon Grysko. Today, guys, is a special episode. I'm going to be in the office with Jack Walsh here at the firm, and Jack is going to be asking me Livonia's questions. We went out to All Things Livonia Facebook group, and we sought input from the community about what sorts of legal questions were on their mind, what's burning you up. This was a really fun episode to do, and I hope you enjoy it. We've got everything from elder law to disability rights to how speed limits work and even more. And if you thought that Sears wasn't going to come up, somehow Sears came up again. So like I said, really fun episode. But before we get started, folks, please like, comment, subscribe, share, tell your friends about us, all those fun things so that we know that you are listening and enjoying the podcast. Unlocking the Law, folks. Let's get into it. Welcome back to Unlocking the Law, everybody. Livonia, you asked, and we over here at Unlocking the Law at Walsh and Grysko are delivering. We've got a number of questions that we've pulled down from All Things Livonia, where I posted on Facebook and said, Livonia, do you have legal questions? What can we do to answer those legal questions for you? And so I'm here with Jack Walsh here at the firm, and we're going to try and do this in sort of an interesting way. Jack's going to ask me some questions. I'm going to answer them for you. And to the extent, if we can get like a good reaction from you guys that there's additional interest in certain topics, I'm going to look at doing a long form episode on a couple of these topics. So, you know, off the top of my head, maybe the blighted buildings or something like that could be one that we're going to want to do a little bit more on. So that being said, Jack, say hi.
Hello, everyone.
And we are looking forward to diving right into it. Little caveat, I suppose. I said this in the post. Obviously, we're not your attorneys. None of you have attorney-client relationships with us. We're going to be kind of answering these questions sort of in the generic. We've not done a deep dive into any of these, which, of course, if we were retained by a client, we would have to do quite a bit more work in order to, assess what are the facts of the situation, what is the law, and how does that apply. Very rarely are things as cut and dry as you might see on AI or on the internet or something like that. So just keep in mind that this, isn't legal advice. And to the extent you need that, then you got to go actually hire an attorney and pay for it. So let's hear it.
Michelle is wondering about elder law, and she's wondering about additional funding on Medicare for assisted living. She wants to understand elder law better.
Oh, okay. All right. So assisted living. So Medicare typically covers, it's like health insurance, right? So it typically covers the sorts of things that health insurance is going to cover. And so usually things like long-term care and assisted living are not going to be covered on Medicare. There are cases where skilled nursing and rehabilitation could be covered, would have to meet sort of certain criteria, and it would have to be healthcare related and not just simply that I need somewhere to live and I can no longer perform the daily living activities on my own. So that's my best take on that. So Medicare is for the elderly. More so, yes, it's an entitlement. Once you hit a certain age, you become entitled to Medicare. And Medicaid, on the other hand, you can think of it as aid for the poor or for people that are less fortunate, have less resources. So with Medicaid, which has income limitations and asset limitations, so in order to qualify for Medicaid, you have to have total assets that are below a certain number, and you have to have annual income that is below a certain number. But Medicaid actually will cover long-term care expenses. But in order to qualify, obviously, you've got to submit a detailed application that talks about all the different assets you have, all your different sources of income. And somebody from the Michigan Department of Health and Human Services is going to go over that with a fine-tooth comb to see whether or not you qualify. Now, there are attorneys out there that specialize in Medicaid planning, so Medicaid. So remember, that's the income and asset-based qualification. There are attorneys out there that specialize in Medicaid planning that will help you to structure your assets in a certain way such that even though you may appear not to qualify, you can be made to qualify. Again, kind of a complicated area. of elder law, something that requires some specialized skill. We've worked with Medicaid planning attorneys in the past on behalf of clients and such like. So it is an interesting area of law. It's very heavy intensity on the regulatory side of things. And so definitely something that you probably don't want to just try and do it on your own, even though it could be expensive. But I would certainly recommend seeking out legal counsel to assist in the Medicaid application process. But that, in a nutshell, I would say is the lay of the land. And none of those things, mind you, cover, I don't think, assisted living. So again, something I might have to do a little bit more digging into, but I think that is the gist of it.
Okay.
Next question, Jack.
Next question is from MC, and MC is looking for some clarification on ADA compliance in the city. He has some concerns about ADA compliance.
That is interesting question, very heavily laden with politics, things that are going on in the city right now politically. The question verbatim, I think, just says something to the effect of how does the city get away with not complying with the ADA? And I actually don't know that I have enough really to answer that question. ADA compliance is not optional. It is mandatory to comply with the ADA. But that being said, there are situations where you could have an undue burden associated with making modifications to municipal programs. And so if it's like astronomically too expensive or something like this, you would not necessarily have to make ADA modifications to a program. So again, a very generic question, but I would say the gist of it is that ADA compliance is not discretionary, but that there are situations where it simply doesn't apply, or in that when you apply it, it's not the type of thing that requires a modification. So the two instances that I'm aware of recently where this has become an issue has to do with early voting in Livonia, which I'm not totally educated on the circumstances behind all that. But as I understand it, there was a proposal to make maybe the city hall an early voting location. And there was some question, I guess, as to whether or not the access points into the city are able to be accessed essentially by folks that may be disabled or in wheelchairs or something like that. The other instance that I'm aware of where this became a topic of conversation is in the new senior center, where there was discussion about whether or not the bathrooms meet the barrier-free design requirements and the accessibility requirements. And that, again, that wasn't really part of the question. I believe that that's probably what this individual was getting at. And unfortunately, I have not done the deep dive and developed the facts to the point where I would need to do that in order to really answer that question. I am not a shill for the city or anything like that. I do know a number of the officials over there, and I have a fairly high degree of confidence in them that they would catch and respond to these things as needed. But again, I just don't know enough about those two particular circumstances in order to know and be able to respond to what MC was getting at in that question. But I guess just to kind of wrap it up and put a bow on it, ADA compliance would generally say that you need to make modifications to municipal policies and programs as needed such that they will be accessible to persons with disabilities. Those modifications, you don't really have to do them if it would create a fundamental alteration in whatever the program itself is. And you don't have to do it probably if it would create some type of significant or undue burden. Usually that's in the form of a financial impact. And then as far as like barrier-free design and stuff like that, those are more building and construction type regulations that one would have to sort of dive into in order to fully flesh that out. So local politics aside, which is always interesting and frankly is the most interesting type of politics, but
totally fair. All right. Scott is asking, why doesn't workman's comp side on the side of the employee when it is very evident, even where the workplace injury is justified? And related, why can workman's comp cut off the employee at any given time and refuse to pay medical bills? Yeah,
that's actually a really, really good question. And workers' compensation law is kind of what I would consider to be like a bit of a club. Like there's only certain practitioners that really regularly practice in workers' comp. So it's somewhat of a specialized area of law. So I'm kind of pulling back from some law school roots and pulling back from a couple of times where I've had to at least be involved on the fringes with some clients that had workers' comp issues. So the way that workers' comp functions is that the workers' comp system is a mandatory system for employers that have a certain number of part-time employees or one or more full-time employees. I think that's more or less how it works. Don't quote me on that. And it is the exclusive remedy for covered employers. It is the exclusive remedy for injuries arising out of and in the course of work. Okay, so what does that mean? What that means is that in lieu of being able to go into court and sue your employer for, say, negligence, right, you instead have a workers' compensation system that provides the remedy for injuries arising out of and in the course of work, employment. So what does that mean in practice? What that means in practice is that your private employers, a lot of your public employers too, of course, will simply purchase workers' compensation insurance. And from that point on, a lot of the decision-making to do with work-related injuries will go through claims adjusters. And it's not necessarily just the employer that's making the decisions, but there's insurance companies involved in claims adjusters and things like that. So the way that the system operates is that the employer can voluntarily pay benefits. For example, there's some incident that occurs at work. There's an injury of some type, and the employee goes to the employer and says, "Hey, I've been injured. I've got this medical procedure coming up that is related to the workplace injury. What do I do?" And the employer will say, "Okay, let me talk to our insurance company." Talks to the insurance company behind the scenes, and for whatever reason, the employer decides that that's going to be covered. Okay, so that voluntary payment of benefits does not then fix the employer's liability going forward as to that injury. So at any point in time, if the employee says, "Well, look, I'm continuing to have issues related back to that injury. I've got all these other procedures that need to be done. I've got all these medications I need to be on," and as things develop, the employer at any point in time can say, "You know what? I don't really think that was an injury that qualified under workers' compensation." And so the employer, in consultation with the insurance company and perhaps with the lawyers that are assigned to the employer by the insurance company, they can decide, "You know what? We're going to stop paying benefits on that claim because we don't really think that qualified," essentially. And so a lot of times you do see sort of an economic decision being made at some point in time to stop paying benefits voluntarily, which then triggers the employee to have to file a more formal claim in the workers' compensation system. So that being said, eventually you could get to the point where like a magistrate within the system orders payment of benefits. And now you no longer just have simply discretion to pay or stop paying, but now there's an order in place that will require it. So it really depends, I think, on where you're at in the process. My heart goes out to people that are struggling with these types of situations. There's obviously multiple factors that go into an employer's decision of whether or not to pay or to continue paying benefits. But that being said, that I would say is a high-level overview of why employers will sometimes voluntarily pay benefits and then also subsequently stop paying benefits. So that, I guess, is the high level on workers' compensation. What do you think about that?
Sounds good. I think you covered it. But I'm ready to move on to the big ticket question.
Okay, what do we got now?
So we got from Rich, and he's wondering why the city can't condemn the vacant, dangerous Sears building, forcing the owner to let it go or demolish it. And he says there must be some sort of eminent domain they can invoke when public safety is at risk.
Okay. What do you know about condemnation, Jack?
Not a whole lot.
Not a whole lot. Okay. So I think people use sometimes the word condemn in a couple different ways. I think the standard thing that people mean when they say condemn would be like demolish, right? Or red tag it.
Yeah.
Building officials and tradesfolk and construction folk will understand the reference to red tag, which is you're red tagging it unfit for occupancy, and maybe it needs to be demolished or something like that. So that's one way in which the word condemn can be used. There's, which Rich alluded to in the question, there's also the power of eminent domain. And do you know anything about eminent domain?
At a broad level.
Yeah. Okay. So high level, what eminent domain is the government's ability to take private property for a public use. And this goes all the way back to, the U.S. Constitution, and before that, eminent domain has largely always been, at least in recent history, sort of an assumed power that the government has in order to take private property and put it into use for the public. So that's another sense in which condemnation, or the word condemn, can be used, is that that's the means by which a local, state, or even the federal government can take private property and put it into public use. So the question is, so one more time now that we've gone through that, the question itself.
Why can't the city condemn the vacant Sears building?
Mm-hmm.
And relatedly about the eminent domain portion.
So if you mean, can the city demolish or cause to be demolished or take some steps to demolish the Sears building, the answer will almost always be it depends. I've not done an in-depth investigation. I've certainly heard rumors that there's infrastructure issues, that there's public health and safety issues. I've heard people say rumors of, there's dead animals inside, there's homeless people living in there. I've heard all sorts of rumors. Now, I haven't obviously personally been out there to confirm any of that, but to the extent you have significant health and safety issues, there could be some type of nuisance claim, perhaps, and that would involve some type of legal action. And one of the remedies maybe that a court could impose there would be some type of equitable exercise of jurisdiction that would require maybe the demolition of the building or some other action on part of the property owner to bring that building up to snuff, if you will, bring it into a safe condition instead of a dangerous condition. The other thing would be that the building code itself and various construction codes all have authority for the local building official or the state building official or even the fire marshal, depending on what the circumstances are. They have authority to issue violations and to issue orders, potentially even demolition orders. And the question, of course, is, well, how do you enforce that? And again, you're probably looking at some type of court action in order to enforce that. So if you're using the word condemn to mean, hey, can we red tag this and say that it's an unsafe structure and require that it be knocked down? Yes, I think a community could do that if the circumstances warrant it, right? So obviously there would have to be some type of factual investigation as to whether or not the building met certain criteria. And if in the opinion of, say, the fire marshal or the building official, it was unsafe for whatever reason, for a multitude of reasons perhaps, then there's a possibility that enforcement action could be taken in order to demolish the building. Now, some people might say, well, this is just, kind of your typical attorney answer. You're not really answering the question. And I think, that's a fair criticism, honestly, because the truth of the matter is that you don't know what a judge is going to do or agree with. It's not as though, Mayor Brosnan is like the Queen of Livonia and can just sort of with her scepter force a property owner to do what the city wants or what the residents want. So the fact of the matter is that property owner does have property rights. And so there is a process that has to be followed in order to get that building, in order to have something done with it, right? Somebody's either got to buy it or it's got to get knocked down, or maybe the city could take it or something like that. But again, these things, there's a process involved with all of them, right? In order to sell the building, that takes the current property owner would have to agree to those terms. In order to get the building knocked down, there's going to have to be some type of legal action on the part of the city in order to make that happen. And I don't know that the city is or is not looking into those options. They may be. I don't have the inside scoop on that. But it certainly could turn into a lengthy legal battle. And so whether or not the city has the appetite to do that is something that the mayor's staff and the mayor herself, in conjunction with the legal department, will have to evaluate and make a determination. For good or for bad, we elect and entrust our public officials with discretionary authority, and they don't necessarily have to exercise that all the time. So even though the Sears building, or we'll go to the House of Denmark, so as not to pick on Sears, with the House of Denmark over at Plymouth roundabouts. Yale would be another one, or the Vassar building at Middle Belt and Vassar. I mean, there's no question in my mind that these buildings are kind of ugly, right? They're aesthetically not pleasing. It would be lovely if somebody came in and redeveloped that space. But, is there a means of the city forcing that? And if there is it economical for the city to do so? And what's the likelihood that the city will actually be successful in deciding to do that? These are all factors that have to be taken into account. And so it's awfully easy for me to sit here and sort of armchair quarterback the situation. But the reality is that it's rather complex, and there are, factors that go into deciding whether or not this is something that can be done, and if it can be done, should it be done? So the part two to that question, if that wasn't a long enough explanation, the part two to that question is, eminent domain. What can the city do there? So municipal governments do have the ability to take private property for a public purpose. That would be something that they would institute through a condemnation procedure. Okay, so generally speaking, what the city would have to do is basically file a lawsuit and say, hey, we're taking this property. The city would have to prove that the public purpose that it has in mind is a public purpose. Depending on what the public purpose is, they would have to meet a standard that is either the standard civil standard of preponderance of the evidence, which is essentially like, hey, I've proved to about the 51% mark that I have a public purpose in mind. Or in the case of, I think, blight, which I think there'd be an argument that maybe the blight standard would apply here. You actually need to have a clear and convincing evidentiary standard, which is going to be significantly higher burden to meet versus the sort of preponderance of the evidence 51% standard. So again, could the city exercise a power of eminent domain? They could try. I mean, the city government has the right to exercise eminent domain generally. Now, they'd have to prove that it's a public purpose, and then they'd have to pay just compensation. And what is just compensation could certainly be litigated and would be litigated, and there would have to be expert testimony probably to establish exactly what the purchase price essentially for the property would be, because that's what this is, right? And to the extent a community is exercising the power of eminent domain, they're exercising the power of forced sale, right? They're forcing a private property owner to sell property to the government. And so that's something that would also have to be worked out. And again, not really as straightforward possibly as you might think. I think there's certainly enforcement actions that could be more easily done, which would be like your classic, hey, you've got property maintenance code violations, so we're going to write you tickets. And there's all different sorts of flexibility associated with municipal civil infractions that could be looked into. Again, these are largely discretionary decisions on the part of the city. And so without having a better understanding of their budget for this, their priorities, and those sorts of things, it's difficult to say exactly why the city is or isn't doing something. But I hope that's a good sketch of what the legal principles involved are.
Good. I've had a lot of people ask me why the owner doesn't do anything. And my understanding is it's owned by a large corporation. Can you shed any insight on perhaps why the owner of the property doesn't want to do anything with it? Maybe tax purposes? Yeah,
there could be. I think, for example, there's, the expenses that you have in maintaining the structure and different things like that could very well be tax write-offs, right? So just by owning the building and having it on the books, essentially, there could be tax benefits associated with that. It also could serve as a source of collateral to the extent you're cross-collateralizing across multiple different mortgages. So I don't know the answer to that offhand, but it does seem likely that there's likely a tax benefit there, and there could be other benefits as well to the owner and their portfolio. So I think probably the tax issue, I would say, would be the one I would look into most closely. As far as what the benefit is to the owner of having this sort of vacant structure just sitting there.
All right, let's go on to the next one. We got Mike. Mike asks, who owns the fence in the backyards?
That is a great question. And it depends, as most things do. So I would say the general rule is that whoever bought the fence owns it. So it's not always the case. I think maybe there's a misconception because most people just move in and there's already a fence there. So I don't necessarily know that there's an easy answer for like who owns which particular fence, right, in any given situation. So I would say as a general principle, the person that bought the fence, that's personal property. Maybe arguably it becomes a fixture as it becomes installed, as it becomes fixed into the ground. Now it's a fixture, it's a part of the real estate. So I would say the person that bought and installed the fence owns it generally. The other thing associated with that is that in many local zoning ordinances, and I can't speak to Livonia's because I didn't look this up, you're actually not allowed to put the fence on the property line. It has to be offset from the property line in many cases. So that would be another thing where you would maybe even need a survey in order to determine whose property the fence is even on. In a case where the local government may say, hey, you can't put a fence on the property line itself, I think that would be strong evidence that whoever's property the fence is on probably owns the fence. Right now, again, in a case where you're just blindly moving in to a new home, now you've inherited some situation with the fence and the property. This is why surveys actually, folks, are very important because you may have some idea of where the lot line is based on where the fence is, but that might not actually be the true lot line. And there is a real property doctrine in Michigan of acquiescence, which is that if you just continually treat something as the property line for a certain period of time, the courts will enforce that and actually say, okay, well, that now is the property line because you've treated it that way for so long. So I think it's important, actually, even though it increases the expense, I think this is a great example of why it's so important to get a survey before you purchase any real property, even if it's just residential. And even though it may seem very straightforward, and yes, even though your realtor may tell you that it's very straightforward, I think there's a good case to be made here that you should probably get some type of survey done in order to confirm where the official lot lines are. And again, I think that is going to itself be evidence potentially of who owns the fence. But I would say probably whoever paid for the fence. Seems reasonable.
That does seem reasonable. He asks, how do speed limit laws actually work in Michigan related to city-owned roads, and what can and cannot be done with them? And you can earn a bonus point here.
Okay.
If you can answer this. If somehow making Plymouth Road between Inkster and Stark a 30-mile-per-hour road were a goal.
So in the Michigan Vehicle Code, there are a variety of regulations associated with traffic. I don't recall exactly. However, speed limits are set by state law. Okay. So for roads that have between certain numbers of access points within a half mile, the speed limits are 40 miles per hour or 45 miles per hour. Or state roads, the default is 55 miles per hour, generally speaking. Neighborhood type roads, the default is 25 miles per hour. So, and then of course there's different, right? I just mentioned different levels of roads. City roads, such as neighborhood type roads. Again, the default in Michigan law is 25. I believe that the locals have some measure of control over their roads. Counties also have some level of control over county roads. So your roads like Plymouth Road, 5 Mile, 6 Mile, those types of roads in Livonia are by and large going to be county roads. And then you've got some of your halfway roads, maybe like West Chicago, Linden, Stark Road. Those are going to be local roads, I believe. And you could probably find this on the city website, exactly which roads Livonia controls versus which roads are the responsibility of like the state or county government. But to essentially the roads are either state, local, or county roads. It's somewhat intuitive that kind of like your medium-sized roads are sort of county roads. Your really big highways are going to be state. And then your small kind of streets that have more of a local feel to them are largely going to be local roads within the control of the local jurisdiction. But there are what you would say are defaults. That's going to be set by statute, 40, 45, 25, 55, 70, et cetera. There is some means of changing that at the local level. But beyond that goes sort of beyond what I researched in order to answer the question for the podcast. But suffice it to say that it's a rather complicated process. And even just changing the speed limit generally, even though you might have the ability to do it, you've got to do it based on objective criteria like traffic studies and things like that. So it's not as though you can just sort of arbitrarily make a decision that this road should be 27 miles per hour instead of 25 miles per hour. So a little more complicated maybe than it should be, but I think that's the gist of it.
All right. Next question is from Heather. And she asks, why do cities like Livonia have to pay to settle so many lawsuits? Those pesky settlements.
Those pesky lawsuit settlements. Well, I think in sort of a tongue-in-cheek kind of way, it's because lawyers keep getting paid to represent clients in those lawsuits, right? And so as a result of that, lawyers are coming up with an ever increasingly creative ways of suing local governments, right? So in Michigan, there is the Government Tort Liability Act, which would generally say that the government is immune from certain types of tort type lawsuits and things like that. So you've got a whole species of lawsuit that has nothing to do with torts, right? So a contract claim would be a great example. That has absolutely nothing to do with the Governmental Immunity Act. And so consequently, to a large extent, no governmental immunity would apply to a contract type case. And so there could be a situation where the city is getting sued by a contractor for maybe like a lack of payment or underpayment or some other breach of their agreement, right? So that's a whole species of claim in its own that doesn't have anything to do with potential governmental immunity. There are other cases like police misconduct types of cases that oftentimes do implicate governmental immunity. And there is federal level immunity, like qualified immunity, to constitutional type claims that could apply. There's also governmental tort immunity at the Michigan state level that applies to municipalities as well. Now, there's two elements of this, right? There is the legal side of things, okay, which is how do you get a case dismissed on immunity grounds? And then, or not even just immunity grounds, but there could be other grounds too. And then there's the practical side of it, which is how do you actually get there and what does it take to do it? Okay. So generally speaking, when somebody files a lawsuit against you, you have two options. You can answer the lawsuit, which would basically be you go through the complaint and you either admit the allegations or you deny the allegations. And once you've done this, that's your answer. And now the case proceeds forward from there. And you have a process called discovery. So the plaintiff and the defendant will go back and forth. They'll exchange documents. They'll take depositions, which is like a sit down out of court testimony where you have a court reporter that will type up a transcript and things like that. And so you've got document exchange, you've got written discovery where you're answering questions, and then you've got live testimony essentially, which is depositions. That discovery process can take a very long time and it can be rather expensive. But at the end of that process, you now have the opportunity to file another motion. And you're basically saying to the judge, look, judge, we've been through this whole process. The plaintiff has not developed any evidence that would allow them to succeed on their claims. And so as a matter of law, you need to dismiss the case. And so that is one avenue of proceeding, right, is go through discovery, get to the end of it, file your motion. The other avenue that I talked about was you file a motion right off the get-go. So you say, look, judge, even if you look at all of their allegations, even if you accept all their allegations as completely 100% true, as a matter of law, their complaint cannot succeed because there's legal standards that they haven't met, even when you assume that everything they're saying is true. And so that would be asking the judge to, again, make a decision before the case even gets started. Okay, so even that as a scheduling matter can take many, many months to get to the point of actually having that motion heard. And then once the judge hears the motion, they might take another number of months to decide. And in the meanwhile, discovery potentially can proceed and things like that. So that, I would say, is a high-level overview of litigation. Now, the practical side of things, what does it actually look like to devote resources to fighting these lawsuits. Okay. Fighting these lawsuits can be rather expensive. Many of the communities in this area have a $250,000 self-insured retention limit, which means that that's essentially their deductible. I'm familiar with one community that has maybe $500,000 in retention, and there's others that have smaller amounts of what we'll call deductibles, I guess, for the sake of this conversation. So even though there is some amount of insurance coverage in a sense that applies, the community is largely spending its own money in the initial phases of a lawsuit. And so there's got to be an economic decision that the community makes is, okay, what are the chances we're going to be able to get the case dismissed very early on? Oftentimes, unfortunately, that doesn't happen, even though in some cases it should. So what are the chances of getting it dismissed early on? How much is it going to cost us to go through discovery, motion practice, back and forth disputes over that you should have given me this document or that document is privileged and you're not entitled to it. And so there's a real economic analysis that has to go into the decision of whether or not to settle a lawsuit. And some communities take the approach that, hey, look, if we can settle this case for the cost of what it would be to defend the case in terms of attorney fees, then we may as well just get rid of it and end the pain, so to speak. There's other communities that may take a different approach and that may say, you know what, we don't want to encourage frivolous lawsuits, and so we're going to fight these until it no longer makes sense to do so for whatever reason. So I would say that those cases can come down to what we would call business decisions, using public resources, using tax dollars to fight these cases. And so many cases will settle. As a general rule, litigation doesn't tend to go to trial. I mean, a very high percentage of cases, 97%, 99%, something like that, will ultimately settle and not go to trial. And so I think that cases involving local governments are really no different. Just has a tendency to make more sense to settle it than it does to go to trial. I actually have an episode planned on this where I'm going to have somebody in to talk about sort of a shifting paradigm that occurs throughout the course of litigation, where you actually, as litigation goes on, your expense goes higher and higher and higher, and your control gets less and less and less over the outcome, right? And so that paradigm is also something to be taken into account. Jack, what do you think the chances are that this question was geared towards recent land use cases in Livonia?
Relatively high.
High, maybe high. Okay. Have you heard about Sheets, perhaps?
Oh, yeah.
Okay, so Sheets is in litigation currently, although I'm not sure on the status of that. That was actually a citizen group contesting. Another case that you may be familiar with was the Wonderland Mall, which is now the Walmart South. And that case was a developer that came in that wanted to do an apartment development, and community came out in strong opposition to that. And as a result, or maybe not as a result, I don't really know the machinations of how it happened, but the project got voted down, the developer sued, and the city council ended up resolving that lawsuit, probably with a consent judgment or something similar that gave the developer the right to develop. It's possible the questioner is getting at cases that don't necessarily involve like monetary judgments, but the fact of the matter is for the money claims, communities have deep pockets, right? They're playing with tax dollars. And as long as that's true, as long as communities have deep pockets, people are going to keep suing them on the money side. Now, on the land use and development side of things, a lot of times the developer is not necessarily looking for a money judgment, although they may have damages that they claim. What they really want is the right to develop. And so in the case of the Wonderland development, I'm not actually sure if the city paid out any money on that, but what they did do was grant the developer the right to move forward with that development. And I think the prevailing wisdom at the time of the Sheets case was that, hey, if we deny this, we're going to get sued and we're going to lose. And so rather than go through the court process and waste a bunch of money on it, we're just going to, approve the site plan because the zoning board has already given them the use variance that they needed in order to develop and things of that nature. Now, just to be clear, I don't know very much about the Sheets case. I have not done a deep dive into it. They're not my client. The The city's not my client. So I'm not well versed in everything that happened with that. I'm just using it simply as an example to kind of highlight, the thinking, I guess, that might go on behind the scenes in a particular instance. So the other problem that you can sometimes run into is that in land use cases, if they don't seek money damages, then there may not be insurance coverage, which means that the defense of the case and everything is on the city and there's no backstop in terms of insurance and things like that. So that could be another reason why a community might look at wanting to resolve those types of cases. So there's just many, many factors that go into it. But I think with respect to, hey, I want to do this development, the city denied me and now I've sued them. And if the developer truly is just looking for those development rights, they've made a calculus. The developer has made a calculus, right? This is how much it's going to cost me in attorney fees to litigate this case. And it's worth it to me to get the right to develop on my property, right? The decision makers at the city have not necessarily engaged in that same calculus at the time that they make their decision, right? They're looking at things like ordinance factors and public opinion and stuff like that. So at some point after the case gets filed, now the community has to take a look at this and say, okay, look, we made this decision. Why did we make that decision? How strong do we feel about that? Is it supported by the law? Is it supported by the factors that are in the zoning ordinance that would be legitimate reasons for denial? People may not want to hear this, but a vast public opposition to a project is not necessarily a legal reason to deny a site plan or something like that. So the fact that a community is overwhelmingly opposed. Is it back on? Okay. Yeah, they'll just cut and paste it back in or whatever. But the fact that a community is overwhelmingly opposed to a particular type of development just does not necessarily factor into the decision there in terms of whether to approve or deny the project. Legally, in the legal sense, obviously, we want the local government officials to take the residents seriously, but it's all got to somehow, in order to be like a legal denial or a legal approval, that public opinion that you're taking into consideration has to tie in somehow to a legal reason for whatever the decision is. So all that being said, if the attorneys are looking at it and saying, well, look, maybe we can make an argument that this denial was appropriate, but maybe we really don't have a great argument as to why the denial is appropriate. And so consequently, let's settle via consent judgment, and maybe we can even negotiate some settlement terms that we wouldn't necessarily have been able to get otherwise. Mm-hmm. And so I think all those things, you'd really have to do a deep dive into the particular facts and circumstances of each case in order to understand kind of the rationale behind why a particular case got settled versus a different case that didn't get settled. But I would say those are some principles generally that people are looking at in deciding whether or not to settle a case.
Yeah. And to your point about that you made a couple minutes ago about how people will always sue the government. I once had a professor tell me there's no better judgment you can get than a judgment against the United States government. Because they're going to pay.
That's a good point. And the reason that that's a good point is because if I sue you, right, or if I sue a business or something like that, at the end of that case, even if I win, even if I get everything from the judge or from the jury that I was asking for, what do I have? I have a judgment. I have a piece of paper. Mm-hmm. I now have to go and enforce that judgment, which means that if the person or the business is not collectible, then all I've got is a piece of paper that cost me a lot of money to get that judgment, right? I've got to go and look at garnishments. I've got to look at what kind of assets can be seized. I've got to look at other means of determining is the person collectible. If they file for bankruptcy, guess what? Now I'm one creditor among potentially other creditors that are vying for the bankruptcy estate. Yep. So there are any number of different problems, right, with a judgment when you get it and whether it's collectible. But the government, they're going to have enough money by and large. And even in some cases, they might have to, do a special tax levy or something like that, or a bond in order to satisfy a judgment, which is something that they can, essentially be forced to do.
All right, let's go to the next question. The next one is from Kim. She's asking, sounds like there are several people in her subdivision that are allowed to violate the zoning ordinance, and she's wondering why that is, even after a traffic study was completed by the city stating that these large RVs impeded a view. And then she asked, why have ordinances if this is the case?
Yeah, that is a good question. It can be frustrating totally to sort of see what you're perceiving as flagrant kind of ordinance violations and being unclear as to why it's allowed to continue if there's an ordinance against it. And I don't know exactly what she's referring to. I know that in most communities, you're not allowed to park like a recreational vehicle in your driveway for more than so many days at a time, like maybe 48 hours or something like that. And a lot of communities will also have an ordinance actually that you can't be parked on the street without having moved the vehicle for, again, maybe 48 hours or maybe 72 hours or something like that. So there are general ordinances associated with those types of things. And ultimately, I can't speak to why it may be allowed to continue in one case, but not another case. So that's difficult to ascertain without being more familiar with the situation. So this gets back to something I mentioned earlier, which is that we elect officials and then they appoint officials. And there's just always going to be some level of discretion associated with government enforcement of ordinances, right? I mean, you see a police officer on the side of the road and he's clocking people, and there may be 50 people going 5 miles per hour over the speed limit, and he might not actually stop any of them, but then somebody is going 12 over, and now he does stop that person, right? And writes them a ticket for going 12 over or something. So there's always just going to be some level of discretion with respect to how the community decides to prosecute certain violations and whether or not it even decides to in the first place. And that level of discretion is just kind of built in to the types of things that they do. So I think we could all agree it would be impossible to go out and cite every single violation every single time. That would be one end of the spectrum. The other end of the spectrum is never citing any violations ever, no matter what. And we're like somewhere kind of in the middle, somewhere in sort of a gray area of how much is too much enforcement versus what is the right amount of enforcement. And I think a lot of that comes down to what priorities does the local government have? What is their budget for enforcement? Have they been receiving complaints in the neighborhood associated with those violations? And then, of course, there's some amount of perception involved here of, does the ordinance officer or the person that's coming out to investigate the complaint, do they perceive it as a violation? Or are they looking at this and saying, well, that may be a violation, it may not be? Or maybe they're thinking, well, look, I've written these violations before for such and such reason, and the judge threw it out, right? The judge didn't agree with me that that was a legitimate violation. And so they might think, well, why am I going to bother writing that violation if I know it's going to get thrown out? So there are any number of reasons why, somebody might get ticketed for an RV and somebody might not. And ultimately, we don't know the answer to that, of course, without sort of more information into the inner workings of not just the government itself, but also the particular officer that may be out investigating or enforcing something. That being said, we talk about selective enforcement or prosecutorial discretion. And generally, folks, selective enforcement isn't really illegal. I mean, you might think it's unfair or immoral or wrong in some sort of theoretical sense, but the law in Michigan does not necessarily view selective enforcement as problematic. In fact, it would only really be problematic in my mind. And again, this isn't my opinion. I'm just saying what my understanding of the law is. It would only be problematic if that selective enforcement was based on some arbitrary classification or discriminatory characteristic. So, for example, selectively enforcing based on race or sex or disability status or, some other protected classification, that would be one possible reason, or some other arbitrary classification. Again, the burden would sort of be on the person complaining to show that this was an arbitrary type of classification or arbitrary type of enforcement. And it quite frankly, those would be difficult cases to prove in my view. But people do bring them. Governments do get sued over those sorts of things from time to time. But ultimately, selective enforcement is not necessarily in itself problematic in the legal sense. Again, you may think it's wrong. You may not like it. It may seem unfair, but that's just the status of the law.
All right. Next question is from Melissa, and she's wondering, what recourse do cities have to stop corporations from buying up housing and renting it out?
Yeah, so that is an interesting question. I actually don't think there is a great deal of recourse to stop it completely. You're talking about, some type of ban on corporate persons, I guess I'll call them, purchasing residential property. I don't know that a local government would be able to do that without some type of mandate allowing it from the state. I mean, there are private property rights in play. As far as like, who do I as a property owner get to sell my property to, right? That could be a significant impediment there. But also you're then taking a whole class of entities and saying there's certain types of property that you're just not allowed to own. So I could certainly see some problems with that type of approach at a local level. Not saying it's impossible. I haven't thought deeply about that or what a strategy would be to accomplish that. I think that there would be some significant challenges in play for the corporate interests there. Now, I will say this, as a home rule city, so Livonia and many of your other communities, many of your other cities are going to be what you call a home rule city, which provides really expansive control over municipal affairs and gives local government a lot of power in order to regulate, municipal concerns and different things going on in the city. So many cities do have ordinances that are regulatory in nature and that regulate, property transfers. So some communities will require inspections prior to sale, right, for residential properties. So you have to get an inspection and you have to meet basic health and safety standards before you can sell a property. So that's one thing that communities can do. Another thing they can do is implement rental regulations. And so there are a number of communities that require inspections. They require a certain level of maintenance to the property, and they require registration and different things like that to make sure that rental properties in town are meeting certain standards for health, safety, welfare of the rental community, the tenant type community. So there are things communities can do in that regard. Again, what are the objectives of the community? What kind of staff does it have? What kind of budget does it have in order to enforce these things? You can get a lot of ordinances on the books, but if you don't have the staff and the budget to enforce, you're relying on a lot of just goodwill compliance, which I would say the vast majority of landlords are going to comply simply based on the fact that they know they have to. And that's what I kind of call goodwill compliance. But there's going to be some percentage, right, that just aren't going to comply, and you're going to have to force their hand. And you have the budget and the experience on staff to be able to do that.
Pauline is wondering why a builder can build houses, never attempt to sell them, and leave them vacant and dilapidated for years and years.
I don't know what Pauline is getting at with that. With construction, time is money, right? And so the longer you're sitting on a property, the more it's costing you, right? Whether it's a construction loan or whether the property is simply, deteriorating over time as you let it sit there. And in the meanwhile, you're having to still pay taxes. You're having to still pay insurance on the property and things like that. There may be some level of utilities that you're paying. Those are all going to be sunk costs unless you can move that property in some way. So I would say that largely the incentive is on the developer to get that house ready and sold. I'm familiar with at least one property, not in Livonia. I think it might technically be in Novi. Very, very nice high-end house. And there's a dispute between the builder and the purchaser, the homeowner. And the builder would love for that property to be complete and closed on. And it's just sitting there vacant, unfinished right now as a result of a dispute. So that is one possible reason, is that you could have a problem like that. Another problem could be just want of a buyer. So the developer may have developed the property, may have built the home, and the sale fell through, and the closing never occurred, and now they're looking for somebody else to come in and buy it. That's another possibility. The developer may have simply walked away from the project for economic reasons or for fiscal problems. Financial hardship, that's another possibility. So all these things are possible, I suppose. Would have to understand more facts, obviously, in any given circumstance in order to intelligently opine as to why in a particular instance a house is vacant. The other thing, and again, this is something that you may not want to hear or you may not like it, but the fact of the matter is that it's not actually illegal to have a vacant property. There's nothing really illegal about that. There could be regulations, and again, I'm not sure if Livonia has this regulation in place or not. There oftentimes are regulations and registrations required for vacant properties, prove you have insurance on the property, register it, who's a good contact, is it going to be boarded up, those sorts of things. But having a vacant property as such, it's not illegal.
All right, let's go to the next question. I'm not sure.
We got to be getting there soon, man. I don't know
Close.
if anybody else is tired of hearing me talk, but I'm tired of listening to myself talk.
Here's a good one. I'm not sure.
Okay, let's hear it.
I'm not sure if this is a legal question. But MC is wondering why an independent audit hasn't been done of the city.
That is an interesting question. Okay, so there are a number of laws governing municipal finance. Cities have to have balanced budgets, right? And those have to be submitted, every year or whatever. And they have to be public record, and they are in Livonia as anywhere else. Also, communities have to have audits. So audits are done. I believe Livonia has an audit. I think its most recently completed audit, its most recently completed finalized audit, is available on the city website. I've seen it. Again, I have no reason to deep dive into it because nobody's paying me to do that. But there are audits done by professional auditors who have audit standards that they have to meet. And so they work with the city finance team to get the information. They put together the audit and they will document their findings. I think in auditor speak, a finding is not a good thing. If there are findings, they'll document those. If there aren't, then they document the work that they did in performing the audit. So I think what that question is getting at is why hasn't the city hired another auditor, somebody different from who did their other audit, which is also an outside firm as I understand it. And I don't know the answer to that. I don't know that there's a legal obligation to have a separate audit done from the audit that's already been done. And so I suspect that there isn't a real reason to do an independent audit outside of the audit that's already done, because there is one already done. And anybody that's interested to know that would simply could go on the city website and view the financial reports that are there, could view the budget, could submit a Freedom of Information Act request to the city in order to obtain that information. The city finances, by and large, are all public record. So if anybody wanted to independently verify certain things associated with the city financial condition and expenditures and things like that, they would be able to submit a Freedom of Information Act request, obtain that information, and then could engage in whatever financial analysis they want to do. I guess the bottom line, to answer the question, I don't know why the city doesn't do an additional independent audit, but I do know that they already do have at least one audit that is done. Another politically loaded question that I want to try and tiptoe around those landmines as I answer.
Well done. Well done.
Well, guys, there was a few questions we didn't quite get to. Andrew, our marketing guru, yanked me off stage there at the end. But what did you think about this episode? Let us know in the comments. And if you want a deep dive on any particular topic, leave some comments. Let us know what you want the deep dive on. If we get enough comments on a certain topic, maybe I'll do a full episode, maybe with a guest or maybe solo, just on whatever that topic of interest is. So let us know. And if we didn't get to your question, or there was a couple we didn't quite get to with the recording time that we had, stay tuned because I am planning on even more content, and some of those questions I may address in a future episode or a short video. So thanks, folks, and see you next time.